to go and implement it, uh, enforce the award, just like any other decree of a civil court. Now, as they say, there is always a slip betwixt the cup and the lip. Theoretically, an award which is not challenged, I'm talking domestic law first, an award which is not challenged can be enforced like the decree of civil court. But we are all aware of the innumerable delays that take place in enforcement of decrees. We also know of the labyrinthine manner in which a decree of a civil court is also enforced. So ultimately, you might be unable to get a domestic award within a specified period. Nobody might even challenge it, but enforcement thereof and getting the fruits of the labor would take infinitely long time because of the tortuous process by which enforcement takes place. Now, this is normally what happens in a domestic award. So what is the fate of a foreign award? So for a foreign award, there were earlier protocols entered into between the country, India and some other foreign countries, who were all parties to two international conventions. One is the New York Convention and one is the Geneva Convention, each of which called upon the member state accepting the convention to implement a suitable machinery for enforcement and recognition and enforcement of foreign awards. Now, originally this was by a separate act by itself, but later on in 96, when the new act was introduced, the Arbitration and Conciliation Act of 1996 made a separate chapter applicable to international arbitration and gave us a mechanism for implementation of foreign award. What is a foreign award is really an issue which the statute has resolved, and the foreign award is defined as in section 44 to mean in the context of the foreign award means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, made on or after 11th October 2016. And then, in pursuance of an agreement in writing for arbitration to which the convention set forth in the first schedule, either Geneva Convention or the New York Convention applies, in one of such territories, as the central government being satisfied that reciprocal provisions have been made, may, by notification in the official gazette, declare to be territories to which the said convention applies. And then there is a special section known as section 48, which deals with the issue. Now, unlike the domestic arbitration award, when a foreign award is presented, it's a two-step procedure. First, the party who objects to its implementation must satisfy the court that this award ought not to be implemented and executed on certain grounds. The grounds are very limited. It's not open-ended card so that anybody can get up and raise any objection, nor is it open to the judge or the court to think that the award is bad because of some reasons and say, I'll refuse to enforce it. The section 48 specifies the grounds on which such an objection can be raised. And some of them are very fundamental objections. For example, one of the grounds is, the section starts by saying, the enforcement of a foreign award may be refused at the request of the party against whom it is invoked, only if the party furnishes to the court proof on the following grounds. What are they? That the parties were under the law applicable to them under some incapacity. Now, incapacity is recognized as one of the grounds for annulling a contract, even under the Indian Contract Act, and mostly in the other foreign jurisdictions also. So it is the result of an agreement between parties who are under incapacity under their respective laws, or it is not valid under the law to which the parties have subjected it, or failing any indication under the law of the country where the award was made. Now, next ground is party against whom the award is invoked was not given proper notice. The fundamental rule all over domestic, or even in domestic arbitration also. If the party is not given a proper notice and is subjected to an award, the fundamental principles of natural justice are not complied with, and that is a good ground for objecting even to a foreign award. The third is award deals with the difference not contemplated by or not falling within the terms of the submission of it. I mean, this is if you have not agreed to arbitrate on an issue and the arbitrator or the tribunal decides to give an award, obviously such a thing would be bad and beyond jurisdiction. Therefore, the executing court under section 40 say, sorry, I will not allow this to be executed. Then the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. Now you have the law of the country where the arbitration took place. Supposing it takes place in London, the Arbitration Act applicable there, or in Hong Kong or in Singapore, the law applicable there. And if it is expressly illegal under that law, it will not be referred. But I must, at this point, add a caveat here, which is something interesting I noticed as a matter of practice, that the French law is very peculiar. If you obtain an award, say in England or in India, and under the law, even if the award is bad and set aside, the French court will say, no, I will independently decide whether it should be implemented or not. This is something peculiar only in the French jurisdiction. Normally, all other countries follow this principle, that if the award is bad under the law where it was made, then a corresponding section like section 48 would say, sorry, it cannot be implemented in our country. But the French people are unique in the sense they say, we don't care whether in your country the law was bad, the award is bad or not. Tell us why it is bad according to our country, and unless it is bad, we will implement it. This as far as section 48 of the Indian Act is concerned, it says that the composition of the arbitral authority or arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement, it was not in accordance with the law of the country where the arbitration took place. If an arbitration took place in England and it can be demonstrated that the resulting award was not in accordance with the law, or that there has been, then there is one more clause which says the award has not yet become binding on the parties. Excuse me. Sorry. That the award has not become binding on the parties or has been set aside or suspended by the competent authority of the country in which or under the law of which that award was made. Now, this is something that supposing you obtained an award in either England or in Singapore and in Hong Kong or any other, Dubai or wherever, and if under the law of that country it is bad, or the competent authority under the law of that country has suspended it or set it aside, then such an award cannot be implemented in India, because that would be a good valid objection under section 48. Apart from these objections, which are generally all over, India had a peculiar problem. And this problem is a creation of our own. In India, most of the high ticket arbitration is all done by government departments. For example, construction, the industries, and huge bridges and factories are established by some government department or something. Now, what used to happen is they used to have a peculiar clause that the arbitrator would be somebody who is named in that, or somebody who is named elsewhere. And on a number of occasions, it was noticed that the arbitration awards against the country were obtained, or rather procured, by bribing or in other words, some other manner, corrupting the process of arbitration. So that is why the question that was always agitated with regard to foreign awards, even from the time before the Arbitration Act became applicable, we had the famous judgment in Redu Sagar Power given by the Supreme Court, a 5-judge judgment, I think, that if it is opposed to public policy, it would not be implemented in India. Now, public policy, as has been always said, is like an unruly horse, and unless you have sufficient bridle to control it, it may go anywhere and anybody may say this is public policy. This was happening quite often in India too. We had the famous case of saw pipes versus ONGC, where our Supreme Court took the view that public policy, any contravention of any law of the within Indian jurisdiction would amount to contravention of public policy, and that created a lot of difficulty in all such international transactions. Finally, the Arbitration Act itself has been amended, and in 2015 they have added uh, two definitions. One is narrowing down the concept of public policy, and then said in section 48 of the Principal Act, they added an explanation which says, for the avoidance of doubts, it is clarified that an award is in conflict with public policy only if the making of the award was induced or affected by fraud or corruption or was in violation of section 75 or section 81. Number two, it is in contravention with the fundamental policy of Indian law. Three, it is in conflict with the most basic notions of morality or justice. Then there's an explanation. Two, for the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Now, this raises very interesting questions. Now, we understand that it was induced by, affected by fraud or corruption. If you can show that it was done, very good, there is no difficulty. In violation of section 75, it can be demonstrated ex facie, no problem. Or it is in contravention with the fundamental policy of Indian law. Now, let us say the Contract Act has some principle. Now, is it the fundamental policy of Indian law, or is it a statute that is applicable? Therefore, this is a debate that has been raging for quite some time. And the Supreme Court recently, I think in a series of judgments delivered by Justice Marima, settled the issue and said there is a difference between contravention of a law and inconsistency with the fundamental policy of law. So they said no, every contravention, if it is done, because the question is this: when you submit to arbitration, you submit to arbitration on the footing that whatever is decided by the arbitrator on facts as well as law or his interpretation of law would be binding on the parties. The Supreme Court said exactly the same thing and said that you submitted it to interpretation by the arbitrator. We are not going to interfere with it unless it goes against the grain of fundamental law of this country. Now, again, fundamental law of this country is a debate, an open issue which can be debated depending on which way the cat jumps. Then the other question is, it is in conflict with the most basic notions of morality and justice. All right, this is something that can be understood. Supposing there is a contract under which somebody says, I'm going to do trafficking in women and children. I'll supply women and children for you for being trafficked. Now, such an agreement, obviously, any country would say this is in contravention of morality and justice. And of course, say something would happen in India, or somebody enters into an agreement, an international commercial transaction, and says, oh, we shall supply you narcotic drugs. Now, is it or is it not? It is not merely a contravention of the provisions of the Narcotic and Drugs Act in India, but it's also against the fundamental policy, because if you open out the Constitution of India and see, one of the directive principles is to ensure that such things are curtailed. Same thing with regard to protection given to women and prohibition of trafficking in women and children. Therefore, if you talk of fundamental policy, the place where we see the fundamental policy of this country is in the constitutional document. Now, if the constitutional document makes such a provision, then of course it is fundamental policy, never mind what the details of a statute are. So these are some of the grounds on which an objection can be raised. And but I must mention that there is a very recent judgment in NAFED case, National Federation of what is this? NAFED is what? National Federation of something or the other. I don't remember the expansion of that. There, a very interesting thing happened. NAFED had agreed to supply certain goods, I think agricultural goods, to a foreign country. And one clause in the agreement had said that if for some reason the export of the material was contrary to the law or prohibited by law, it shall not be done. Now, there was a situation when the international price was much lower than what it was to be sold at. So the government of India issued a notification and totally banned halfway through when the contract was being implemented. So there was a dispute, and the foreign arbitrators took the view, the tribunal constituted elsewhere, took the view that they were not bothered with it. Then the award had to be implemented, and the money had to be paid to the party who was aggrieved. Now the matter ultimately ended up in the Supreme Court, and the Supreme Court uh, made a slight distinction. The Supreme Court, of course, said fundamental principle of law and all that, and then finally said, hey, look, under clause 37 of 36, whatever that clause was, it was clearly agreed between the parties that if there was a prohibition in respect of the export of goods by a process known to the by legal process, then it would not be done. Therefore, in the face of the prohibition, there was no way NAFED could have applied to you, and therefore, to that extent, we say that the contract itself came to an end the day the government of India banned it. And on that ground, it said, well, this is not a word which can be implemented, and they refused to allow the implementation of the word in Section 48. Barring that, of late, the Supreme Court has consistently taken the view that the fundamental policy of law is not every detail of every statute in the country. And that is how the International Committee has been maintained. And this is consistently so because, it's a very paradoxical situation that on the one hand, we say we want foreign countries to come and invest here. And when they want to come and invest here, they want to be guaranteed that their money is safe here. That is why you have the bilateral investment treaties. You have this kind of protection under the domestic jurisdiction for enforcement of our international awards. And you all must have read in the newspaper what happened in the case of Vodafone. That was an extreme case. Of course, the matter is still open. The debate is open. They may still challenge it by some ground or the other. And one doesn't know what the Supreme Court will say. But this has been happening too often. And since I was concerned with the first one, which really changed the law in the country. The first one was that White Industries case. Then you had one from Karnataka, what is that? Antrix case. And the third one that I noticed was the Vodafone case. In all such cases, apart from the legalities of the matter, one raises a fundamental moral issue that you agree to do something. Can you just go back just because it is inconvenient and say, sorry, I will not do it? Is it justifiable for a nation to do that? Is an issue that needs to be seriously considered. Well, it may choose on particular occasion to say, yes, it saves me crores of rupees or it saves me $1 million. But is that the right thing to do? Are we not, as a country, obliged to? Ours is a country which has produced brilliant minds like Buddha and Mahatma Gandhi, to name two of them. Are we going to? And we were known to teach morality to the entire world at one time. So do we have the moral stature to say, yes, we have agreed to it, doesn't matter, it causes a little inconvenience, we'll abide by it. That should be the spirit in which arbitration is supposed to be carried out, not as a litigative process. Otherwise, what is the difference between litigation and arbitration? That, dear friends, is all that I need to say at this opening juncture. And I leave it to Dhruti to raise whatever questions she wants. And I'll answer them to the best of my ability.
Thank you so much, sir, for your valuable inputs on this aspect of the topic. But we'll keep the interactive session post Salman Khurshid sir gives this thing, and we will definitely go ahead with that. May I now request Salman Khurshid sir to please take over and share some inputs about domestic arbitral enforcement awards.
Well, thank you very much. I think Sri Krishna has given the entire canvas of arbitral proceedings, and I think touched upon the very, very critical dimensions that obviously overlap and connect the arbitral proceedings that are described as domestic and those that are described as foreign. Now, since I have to speak specifically on enforcement of domestic awards, we need to keep in mind one very specific thing, and I think we have that takeaway from Justice Sri Krishna's exposition, which is that the courts were straining the courts in our country were straining to arrive at some of the propositions that finally get formulated to begin with in the 1996 Act. Then when we find that that is not adequately addressing the concerns and the aspirations for which we seek arbitration, then we get the 2019-15 amendment, which significantly puts into the statutes the propositions that the courts were straining to arrive at. And then, of course, we have the 2019 amendments, which have fine-tuned the entire process of arbitration further. But enforcement is significant, and there, as it's already been mentioned, what we need to look at is Section 34 and then Section 36. 34 essentially is the challenge to an award, and how deep and how wide can the challenge be to an award is what goes into 34. Clearly, the inclination of courts was that the very purpose of arbitration will be defeated if there is a replication, as it were, beyond arbitration of doing the same thing all over again, i.e. virtually having an appellate arbitration. That's what the courts discouraged right from the beginning, even before 1996. Now, there could have been a varied kind of response, sometimes as much as we expected, sometimes less than we expected. But 34 made it clear that there are only limited circumstances in which a challenge can be made, and those limited circumstances are important and have been, over the years, have been fortified. And I think that's the beneficial part of the Arbitration Act. The Arbitration Act is, as Justice Sri Krishna has said, is in an alternative method of dispute resolution by which all the disadvantages, there are many advantages of adjudication and going to courts of law, but all the disadvantages that cannot be removed are disadvantages that are taken care of through arbitration. And that's the reason why the whole world repeatedly attempted to find the schemes, the formats, and the platforms by which this method of conflict resolution could be taken forward. So 34, as I said, is which allows the challenge, and they're making it very clear, having started with court judgments. Then the 34 itself made it very clear, if you read in 34 subsection 2, that the points that just has been raised, incapacity would be one, arbitration agreement not valid under the law to which the parties have been subjected. The party making the application was not given proper notice, i.e. the natural justice dimension, that they didn't have proper notice, they didn't have chance to place their point of view. And then, of course, the actual terms of the agreement did not cover the issue in arbitration. That would obviously be the very limited nature of the challenge that there could be in 34. But what 34 allowed and did before the amendments came is that if you challenge an award, then the enforcement would get suspended, and that you couldn't proceed with the enforcement of the award while 34 challenge was pending. And 34 challenge, of course, could go on for some time, and then there would be an appeal from dismissal of 34 in case there was such a dismissal, and you would go in 37 in the appeal. So what 34 did is it kind of gave a second life to the person who wanted to question the award, and therefore within a limited extent, i.e. you couldn't say that reappreciate the evidence. You couldn't say that there was not enough evidence. You couldn't say that the facts have been found by the arbitral tribunal have to be reviewed and they have to be reversed, or they have to be replaced. All that could not be done. It was not an appeal. It was a challenge. It was not an appeal. A challenge in a very limited way is all that could be done. But even for that, even to that extent, the enforcement would get suspended. And the enforcement, therefore, meant that the person who succeeded in the award would still have to wait for at least 2 more rounds, i.e. under 34, 37, and then possibly, as in many cases, the matter traveling up all the way to the Supreme Court. Of course, if these matters didn't get to the Supreme Court, and those wonderful judgments that Justice Sri Krishna just mentioned, and some that I'm just going to take you to in a while, those judgments would not have come, and we wouldn't have opportunity in a webinar like this one to sit and chat about dimensions of this alternative way of resolving conflict. So now, what happens after the amendments, of course, is, and let's go now to the enforcement section, which is section 36, and let us see what 36 now does. What after the amended 36 does. If we look at 36, it says where the time for making an application to set aside the arbitral award, which is normally 3 months, under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provision of the Code of Civil Procedure 1908 in the same manner as it were a decree. So it would be, from there would be no necessity of a decree being drawn up before you could proceed to execution. Of course, there are problems with execution that we've just been told, but now what would happen is when the time passes, the period is over for challenged under 34, you would then be able to treat this as a decree and proceed for execution. But it's subject to subclause 2, which is subsection 2, where an application to set aside the arbitral award has been filed in the court under section 34. The filing of such an application shall not by itself render the award unenforceable unless the court grants an order of stay of the operation of the said arbitral award in accordance with provisions of subsection 3 on a separate application made for that purpose. So it's not automatic anymore. There'll have to be a separate application. The separate application will be obviously opposed by the other side, and it's only subject again to subsection 3 that the court will then pronounce first on what is to be done with enforcement. There could be enforcement subject to giving of adequate security. There could be partial enforcement, etc. And that will come here in subsection 3. Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of the operation of such award for reasons to be recorded in writing. So we can see how significantly difficult it will be for somebody who is trying to escape enforcement, that there would be possibly an opportunity to bring home to the court why it's necessary that there should be enforcement. There could be a whole lot of reasons for that. And that could be done through such terms and conditions being imposed that will ensure that it's equitable and just for both sides. Of course, we keep in mind that the preservation of the subject or the assets under section 9 through a court order and section 17 through appropriate orders passed by the tribunal itself would be in the backdrop of whatever it's to be done by way of enforcement. So this is a very significant step forward that 34, the amendment of 34 and 36 have provided. So that's one important thing. Let us now also keep in mind, because we were to speak both about foreign awards and domestic awards. Let's keep in mind as to the manner in which the Act itself, the Arbitration and Conciliation Act of 1996, has dealt with these two separate categories for a variety of reasons. These categories, because they couldn't be lumped together. There are different circumstances that apply, different interweaving of laws, domestic laws as against laws of India, etc., when the foreign award is concerned. So Chapter 1 has in the Act provides for dealing with acts which awards that are described as domestic awards. And then, as we just saw, there's a chapter 2 that deals with foreign awards, and the explanation and the definition of foreign awards is given there. In chapter 1 itself, in the definitions, if we look at the definition of chapter 1, in the definition, if you look at subsection 2 of section 1 in chapter 1, I will just quickly read that to you. This subsection 2 begins as, this part shall apply where the place of arbitration is in India. So the domestic award is an award where the place is in India, and foreign award is the place of arbitration is abroad. That's a major distinction between the two. But what happens if there's an international arbitration, i.e. there are parties, or at least one party is a non-Indian party, but the place of arbitration is India? Would that be a foreign award, or would that be a domestic award? We will see the judgments just now. That would be treated as a domestic award, even though it's in a sense an international arbitration because of one party being from another country. But it's the seat of arbitration important, so the territorial dimension of arbitration is what is being kept in mind. So if you look at subsection 2, this part shall apply where the place of arbitration is in India. So that's clearly what the domestic awards are. But then look at the proviso. Provided that subject to an agreement to the contrary, the provisions of section 9, 27, and clause A of subsection 1 and subsection 3 of section 37 shall also apply to international commercial arbitrations, even if the place of arbitration is outside India, and an arbitral award made or to be made in such a place is enforceable and recognized under the provisions of Part 2 of this Act. So it will be a foreign award because it would be outside India, yet for purposes of enforcement, the benefit of these sections would be given subject to a contrary agreement between the parties, and therefore would help in the manner in which a foreign award would be enforced in our country. That is a significant outreach to, as it were, foreign awards. Now let's see where we stand with the issues that have been touched upon, but I'll just go over them again. So what we see is that the amendment of the 1996 Act in 2015 provided, amongst other things, more effective and rapid enforceability under 34 and 36. Then let us look at what else has been done. And as I said, the courts were already stressing these dimensions were pulling in that direction. But what the amendment did completely clarify and consolidate and specify is the following, if you might note, it's important. The court has to decide the challenge to the award is not an appellate court. I just explained that. It's not an appellate court. It just looks at the challenge specifically within the confines of the challenge. The court which has to decide the challenge to the award is not a court of review. It does not review the award. It's not a challenge to the award. It's not an appeal. Challenge in the sense of an appeal. It's not proceedings in which the award can be reviewed. The court which has to decide the challenge to the award is not to substitute. It does not have the power or jurisdiction to substitute its own version of the award in place of the award. It cannot say that if I was the arbitrator, this is what I would have done. The court cannot do that. Then prima facie cannot set aside the award if it's a reasoned award, it can't set it aside. And of course, awards have to be reasoned unless the parties have agreed, because in a case where the award is not reasoned, the application of mind and assessment of application of mind becomes virtually impossible. Then we come to the award cannot be set aside merely by saying that, well, it's a plausible view. It's a plausible view, but there can be another plausible view. It cannot be set aside in terms of an alternative plausible view. Finally, or almost finally, the critical decision on facts, on evidence, has to be left with the arbitrator. That critical issue of facts and evidence cannot be, as I said, there cannot be a reappraisal, and therefore the tribunal is described in the terms of being the master of evidence, being master of various things in law have become commonplace knowledge, commonplace conversation in our times. And therefore, finally, public policy comes in, that it can be set aside on grounds of public policy, and that what that public policy is something that Justice Sri Krishna has already touched upon. But let's just look at public policy is how it's been described in section 34 2b, 2 subsection 2 b and Roman 2, which now reads that the award can be set aside if it is in conflict with the public policy of India. And then there's an explanation added to that, which Justice Sri Krishna had mentioned. First one, as he said, is quite blatant and understandable. If the award is induced by fraud or corruption. The significant bit is if it is in contravention with fundamental policy of Indian law. So public policy then redefined in terms of fundamental policy of Indian law. And as Justice Sri Krishna said, this remains an open question. The jury is still out on it as to what is fundamental. And some judgments have, of course, given an indication as to what is fundamental policy of Indian law. Is there then something by the nature of a similar distinction as there is in the basic structure of the Constitution, the basic structure being a structure that cannot be touched in a constitutional amendment, everything else can be. The explanation that's given, explanation 2 to this above section is that the test as to whether an award is in contravention with fundamental policy of Indian laws shall not, and I repeat, shall not entail a review on merits. So it's nothing to do with merits of the adjudication that the tribunal does. It has to do with something quite apart from it. Then, of course, there is the 2A subsection 2A that has been added. An award can also be set aside if it is vitiated by patent illegality appearing on the face of the award, but that doesn't mean that an award can be set aside on the ground of an erroneous application of law or by reappreciation of evidence. So you can see that we are walking on thin ice, or if you like, on an edge, and the Supreme Court in due course will frankly have to do more to give us guidance on which side do we fall on. The jumping of the cat, as Justice Sri Krishna said, we'll have to wait to see which side the cat jumps to. So then from this bare perusal of 34, as I've mentioned, it is clear that the court seized of the application for set aside the award will be extremely careful, reluctant in setting aside the award because the Act has now provided a ring fencing of the extent to which the court can interfere, and then of course 76 that I've already said to you that section 36 is very critical because it doesn't allow for suspension of enforcement. Very quick look at the public policy issue. Prior to 2015, there were 4 limbs. So the courts had developed 4 limbs of public policy. The 4 limbs of public policy, i.e. fundamental policy of Indian law, justice and morality, interests of India, and patent illegality, were brought about by case law. And this you would find in ONGC versus Soap Pipes that was mentioned in para 31 of ONGC versus Soap Pipes. In Associate Builders versus DDA, this you would find in para 19, Associate Builders and DDA. In para 21, DDA versus RS Sharma. So these 4 heads you would find there. So there was clearly, even before the amendment, there was, and even as we went along, looking at what were the contours of intervention, it was clear that the courts were pro-enforcement. They were pro-enforcement against interference, and found specific grounds on which to refuse to interfere. Let's look at some fundamental policy of Indian law cases. As I just mentioned, we mentioned Associated Builders and Soap Pipes. So these would include the fundamental policy of Indian law, would include disregarding orders of superior courts. So there are orders of superior courts, and those are not noticed, or those are disregarded by an arbitral tribunal. There would obviously be interference. We've talked about natural justice already, and the natural justice issue will also be found in Associated Builders versus DDA, in ONGC versus Western Gecko International Limited. Then there, of course, was one very critical, and I think this is kind of a catch-all net that always remains, is the arbitrators cannot be perverse and irrational insofar as no reasonable person would come to such a conclusion. This is the famous, as we all lawyers know, the Wednesbury reasonableness test. And you will find this again in Associated Builders, as indeed in ONGC and Western. So clearly, the arbitrator, although the sole judge in respect of the quality and quantity of facts, i.e. the evidence that they require to come to a conclusion, will be left to him or her, as the arbitral tribunal may be. But there will be scope for a court to interfere where a decision can be described as being perverse or being described as being a decision that no reasonable person could arrive at. So these will be the contours of where the fundamental policy of Indian law, which in a sense itself is a subset of public policy. Public policy is, of course, much larger, unruly horse, as Justice Sri Krishna described it, etc. Let's just look at quickly at the issues of public policy, interest of India. This is something on which we'll have to have people with broad shoulders, judges with broad shoulders in taking a view that cannot be parochial. Many of us are restricted to taking positions because it's very easy to seem to appear not to be adequately caring about your country. And therefore, it's us against them, us against the world. There, of course, the judicial mind is what one can rely upon to say that interest of India is something that should be seen in a larger context, not in a matter of how much we lose and how much we gain, but what stature and standing we retain in the world as a country that wants to be a leader of the world. A war against justice and morality, of course, Indian courts and English courts have tried to focus on this scope of justice and morality in terms of matters such as sexual immorality and so on. But this justice and morality, I believe, has scope in the future, because there will be occasion for the Supreme Court to develop the idea of constitutional morality. Constitutional morality is a very challenging and interesting idea that the Supreme Court has developed in recent years. I think it's not been fully explored, but if we do develop the concept of constitutional morality, I believe somewhere it would become relevant also to this significant dimension of justice and morality as being a ground for challenge. And then, of course, ultimately, we've already looked at is where there is a patent illegality that also has enough leeway, enough scope for the courts to interfere where they decide that it's important, where it is going to be interfere, etc. There'll be some standard descriptions of that, fraud and corruption being one, contravention of substantive law, and not just simply a wrong interpretation of the law. So a law can be interpreted one way or another way, as we know, through our understanding of the appellate system in the common law, but that a mere misinterpretation may not be sufficient to bring it under grounds of patent illegality. But then the contravention of the act itself, the act by which the jurisdiction is granted to an arbitrator, that would be important. Perhaps where the arbitrator fails to consider terms of the contract and the usage of the trade as required under Section 28, subsection 3 of the Act. So that's also going against the Act itself, as it were. And of course, finally, the arbitrator fails to give reasons for his decision, but that also is covered by the Act. So that's broadly the kind of canvas that we have on enforcement. We do know that things have improved enormously through the amendments that have come. Perhaps we need to wait for another 3-4 years to see, maybe 5 years, to see how well it's doing and whether it calls for another round of amendments. This has to be seen in the context of the regime that is now, a strict regime that is now applied to arbitrators, the disclosures that they have to make, and of course the time that's given to them to finally conclude arbitrations, etc. I think this larger overall picture has to be seen as we see how the improvements in enforceability would continue. So that, I believe, may be a good starting point. I'm sure that there will be a lot of questions and there will be a lot of ideas that will emerge. Thank you very much.
Thank you so much for the very deep, detailed, enriching concept of domestic arbitration enforcement of the award that we got through to you. So we have two important, people who have joined in here is Professor Dr. Uke, who's a Vice Chancellor of MNLU, and also Dr. Anil Vairath, sir, who's a Registrar of MNLU. May I please request Dr. Uke, sir, to give his thoughts on this subject to the panelists and all of us here. Dr. Uke, please.
Thank you. I hope I am audible.
Yes, sir.
Honorable Justice B.N. Shri Krishna, sir. Honorable Advocate Salmanji Khurshid, sir. My colleague, Registrar Dr. Anil Vairath, the head of the PG department, Dr. Anand Raut, all other distinguished participants and dear friends. At the outset, first of all, I sincerely apologize because I had another meeting, a very urgent and important meeting, executive council meeting at another NLU online. So that's why I could not join right from the beginning. I welcome all the panelists, particularly Honorable Justice B.N. Shri Krishna, sir, and Advocate Salmanji Khurshid, sir, for this webinar on enforceability of arbitral awards in India, being organized by the Postgraduate Department of Legal Studies, Maharashtra National Law University, Mumbai. Before I say anything about the topic, let me add here in that the university was established 5 years before. This is now 6th year. Our first batch has been passed out in the month of June, a graduate batch, and we offer graduate courses in BA LLB honors as well as postgraduate in LLM 1-year course. However, from this academic year, we have launched 3 master's degree programs, one of them with which Honorable Justice B.N. Shri Krishna sir is also associated, that is MA Executive in Mediation. I'm really happy to share with all that Maharashtra National Law University, Mumbai is not only the university in India, perhaps it is the university in whole Asia, which is offering this postgraduate master's course in mediation. Similarly, in association with SEBI and its institute, National Institute of Security Management, we are offered from this academic year another master's program, LLM in investment and security laws. That is also being rolled out. And the third one is LLM professional. Those who graduate from law, however, because of the service or because of the judicial service or practice or any other service, they are unable to pursue their masters. So for such people, we offered LLM professional course. So this pandemic did not deter our spirit and energy, and we went ahead with all these 3 masters program from this academic year. Having heard the 2 stalwarts, Justice B.N. Shri Krishna sir and Advocate Salman Khurshid sir, it would be improper on my part to say anything about the topic because their rich knowledge and vast experience with which they have enlightened us. So nevertheless, I would like to share a few thoughts about the topic, that is enforcement of awards in India. As we know that the growth of international commerce has necessitated the creation of efficient methods of resolution of disputes. In some situations, securing an award or a final judgment from the courts may only be a battle half won. This is especially true in the Indian context. We have come across situations where the opposite parties decide to not participate in the arbitral process or abandon it in a midway. The enforcement of these awards judgments where the party is in absentio is sometimes more complicated than one where the opposite party has participated in the proceedings. In some situations, objections have been raised even against costs awarded by the tribunal or the jurisdiction of the tribunal or court, as the case may be. Therefore, the stage of enforcement of an award or decree warrants a high degree of caution. The procedure for enforcement and execution of decrees in India is governed by the Code of Civil Procedure, while that of arbitral awards in India is primarily governed by the Arbitration and Conciliation Act 1996 as well as the CPC. Domestic and foreign awards are enforced in the same manner as a decree of the Indian court. Thus, it is true, even for consent, awards obtained pursuant to settlement between parties. However, there is a distinction in the process for enforcement of an award based on the seat of arbitration. While the enforcement and execution of Indian seated arbitral awards, that is domestic award, will be governed by the provisions of Part 1 of the Act, and enforcement of foreign seated awards, that is foreign awards, would be governed by the provisions of Part 2 of the Act. A few steps that are crucial for ensuring successful enforcement of arbitral awards and execution of decrees are making effective service and opposite party judgment debtor is crucial to prevent objections at a later stage, taking necessary steps by way of attachment, notice, arrest, appointment of a receiver, or in another manner. Principles of natural justice apply to even execution proceedings. As enforcement of domestic awards, so far as is concerned, as award holder would have to wait for a period of 3 months after the receipt of the award prior to applying for enforcement and execution. During the intervening period, the award may be challenged in accordance with Section 34 of the Act. After the expiry of the aforesaid period, if a court finds the award to be enforceable at the stage of execution, there can be no further challenge as to the validity of the arbitral award. Prior to the recent Arbitration and Conciliation Amendment Act 2015, an application for setting aside an award would tantamount to a stay on proceedings for execution of the award. However, by virtue of the Amendment Act, a party challenging an award would have to move a separate application in order to seek a stay on the execution of an award. Similarly, in case of the enforcement of foreign awards is concerned, as India is a signatory to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, as we call it as a New York Convention, as well as the Geneva Convention on the Execution of Foreign Arbitral Awards 1927, as we call it as the Geneva Convention. If a party receives a binding award from a country which is a signatory to the New York Convention or the Geneva Convention, and the award is made in a territory which can be notified as a convention country by India, the award would then be enforceable in India. The enforcement of a foreign award in India is a two-stage process which is initiated by filing an execution petition. Initially, a court would determine whether the award adhered to the requirement of the Act. Once an award is found to be enforceable, it may be enforced like a decree of that court. However, at this stage, parties would have to be mindful of the various challenges that may arise, such as objections taken by the opposite party and requirements such as filing original authenticated copy of the award and underlying agreement before the court. As we have heard, as I've said, both these stalwarts, both the legal luminaries, Justice B. N. Shri Krishna sir, as well as Advocate Salmanji Khurshid sir, And I am confident that the further deliberations would add into the knowledge of all the participants as well as ours. With this, I wish you all the best. Once again, thank Honorable Justice Sri Krishna sir and just Advocate Salman Khurshid sir for having accepted our invitation. Thank you so much.
Thank you very much. Thank you.
Thank you so much, sir, for giving your inputs on the subject here. Now we'll move to the interactive sessions. So for that, I have few questions set out here. First question goes for Justice Sri Krishna. In context to foreign award, which court would have jurisdiction over an application for recognition and enforcement of arbitral award? Generally, when it comes to enforcement, so which would be the actual jurisdiction point, sir? If you could throw some light on it.
Executive. As long as the foreign award has been subjected to the process under Section 48, and if objection under Section 48 has failed, it will like the original decree in the civil court. Executable. If it is in Bombay, it will be executable depending on the monetary value in the Bombay High Court or in the principal city civil court. And in the districts, it will be the district court or whichever is subordinate court, depending again the monetary value. Of course, if it's an international
from the international perspective, so the foreign award, where do you?
foreign award, you can always expect that its value will be so high that the matter will be the original jurisdiction of the High Court, whichever is the High Court.
Yes. Thank you, sir. Now I have a question for Salman Khurshid, sir. What are the documentations and procedure to obtain recognition of an arbitral award in India? The basic procedures, because this is for the students' benefit. If Salman Khurshid sir could answer this from the domestic perspective, when we have to basically enforce the award, what are the documentations and procedure part of it that we could do?
There is no real problem as far as domestic awards are concerned, because domestic awards, the award itself, as I said, once the period for challenge to the award is over, then the award can be executed like a decree, and therefore there is no further thing. It's just the award itself that has to be produced, and the award as produced is the award that will be executed. So as far as domestic awards are concerned, there isn't a great problem there at all. The only thing, again, is, as has just been said to you, will be the question of the value as to what would be the jurisdiction in terms of value. That would have to be decided. I think for international arbitration, foreign awards, the problem really becomes that sometimes you have to end up in district courts to enforce something that may have been decided in New York or Singapore, and the clogging of the roster of the district courts is a great discouragement to a lot of these people. But that's really something that needs to be sorted out in due course.
So we have a further question for you. Thank you so much for this answer. What, according to you, are the major difficulties faced by the parties while seeking enforcement of arbitral award in India? Major difficulties which parties would personally face. So,
I think
we've covered
no more than parties feel a difficulty in adjudication. No more than that. How do you serve the other party? How do you ensure that the courts have time to give priority and hear your matter? How do you overcome the backlog of cases and the dilatory tactics that many of our colleagues at the bar are very good at? Some of us are perhaps lacking in some of that expertise that is not taught to us in law school, but this is what you learn in the real world rather than in law schools. So I think these are the difficulties, the general difficulties of adjudication and law in our country, which we are working on. I think that steadily both the judges and the government have steadily been working on it, amendments to appropriate legislation. And I hope that we will get there. There's so much that we have learned about speedy and effective litigation during this COVID period. The use of technology. So much has been now learned, which is something that we felt very, very concerned about and were reluctant to take on board. But I think much of this, this will at least be a silver lining of the COVID period.
Thank you so much, sir. Sir, and one more question for you when it comes to execution, sir. What are the different modes? Basically, is it like the CPC procedural that we do, or are there any particular modes that we need to focus on when it comes to execution of the award?
It's entirely CPC. It's entirely CPC. It works exactly the way it would work as far as execution of a decree is concerned. So there isn't anything special. I don't know whether there is an argument that for enforcement of arbitration awards there should be some special procedure, but I've not come across such a point of view being argued vigorously anywhere.
I don't think even Justice Sri Krishna has come across, even I have. So just wanted to clarify on that, right? Thank you so much, sir. Now I'll ask a question to Justice Sri Krishna. Sir, can I pose a question to you? Yeah. What are the main reasons, in your view, due to which domestic courts decline to enforce foreign arbitral award, basically?
Section 48.
Yes,
Section 48 is the only one under which they can refuse to recognize the foreign power. Once it is recognized under Section 48 and it overcomes all the objections, it is like any other civil court decree. It has to be executed. Subject to the delays and subject to all the dishonest practices that the lawyers adopt of putting in some counterclaim somewhere.
What is a hitch which we find in the practical sense in this issue, sir? What are the ways we can overcome it? Because the procedures are very simplified.
As a lawyer practicing in India, you have seen what happens. The moment there is an execution against a particular property, suddenly somebody will come up and say, I have a right in that. And he'll find an objection in the execution proceeding. And that objection, fortunately, earlier it had to file a substantive suit. Fortunately, now the civil procedure code is amended. That objection will have to be treated as a competent suit and tried. In the moment you say a suit has to be tried, you know what's going to happen.
Yes.
Then the question of notice and then service, he'll dodge it 20 times and he will bribe the bailiff, and the bailiff will say, this man is not available in this. Also, I made 20 attempts to serve him and not having gone there even once. And then substituted service, and that substituted service will also be objected to. Then there will be a publication. The publication is not in Marathi, but it is in some other language. I speak only Malayalam, so I don't understand. That objection will be raised. And these cases have to go through all the gamut of things. And at the end of our career and probably our life itself, something will come out of the whole thing. But this is all the dodges in the execution. But as far as Arbitration Act is concerned, luckily it stopped there. You see, unfortunately, what has happened is execution is not so difficult in foreign countries. That is why people want to go and do it there.
Exactly, sir.
They won't want to do it here because of, say, look, I have traveled wide and far all over the world. I have brushed shoulders with famous international judges and lawyers. According to me, none of our lawyers and judges are in any way incompetent or less competent than any foreign lawyers and judges. The only problem here is, of course, the reason for the problem are quite different, that we have discussed it for all 50 years and nothing has come out of it. That there is tremendous amount of backlog, tremendous amount of clogging of the system. Now, since the judge has to do hearing substantive issues, also do execution, he is going to be lost in this, particularly when all these kinds of small objections are raised. And because he is now governed by Civil Procedure Code, he has to deal with it. He has to give them sufficient notice. He has to deal with the principles of natural justice. Otherwise, somebody in the High Court or in the Supreme Court will rap him on the knuckles. This happens.
So I quite agree to what you say, because this is the only hitch where the enforceability part and the delay, the execution part also comes into play. But there is no cure or no per se remedy we see, like, you know.
The remedy is to straighten out the civil procedure. Now that is a task which great stalwarts have failed in. I am not going to say I can even suggest a remedy for that.
So now one more question is, an aspect of stamp duty payment is inconsequential to enforceability of a foreign award in India. Shouldn't there be guidelines to that means, because there's a lot of revenue loss, because stamp duty aspect when it comes to enforceability of a foreign award is per se evaded, like if we go to see. So don't you think?
How do you mean evaded? I didn't
In
understand.
that sense, the stamp duty is inconsequential to the enforceability when it comes to it. What's your view on that overall? Like,
No. First of all, when a foreign, let's take domestic award. A domestic award needs to be stamped before it can be executed. No, there is no difficulty. So why is there a distinction if it's for either an exemption? I'm not come across an exemption.
Can you throw some light, because there was a controversial topic on it, so which we thought if you could put some.
If an award is made in, let's say, in Singapore or Singapore or Hong Kong or somewhere, and it is brought for execution here, first barrier it has to face is Section 48, right? That itself takes some time. Let us assume that that barrier is successfully jumped. And then that becomes capable of execution as any other decree, right?
Yes, sir.
At that point of time, if it were a civil decree of a civil code, what would you do with stamping then? The same thing should apply. Why? I don't see any difficulty. Unless there is I'm not aware of any special exemption under the Stamp Act.
I have not come so, but then there are some controversial things that it's easier to wait it out. Some controversial things going on.
Controversy, because once it crosses Section 48, it is no good or no better than
I quite agree.
the decree of a court in India.
Yes.
So whatever happens to an Indian court decree will happen to it.
Right, sir. So now we have questions from audience. Any one of you can answer. Please, can the panelists provide? Kamini Ahuja has asked a question. Please, can the panelists provide their inputs? One moment, it's just gone here. You're right here. Yeah. Please, can the panelists provide their inputs on enforcement of an award in India passed by a non-reciprocating country? So,
with non-respect, you could do nothing.
okay.
If I remember rightly, I had a practical problem. I remember there was a civil suit filed in India in respect of a contract between an Australian company and an Indian company. A decree obtained, it couldn't be enforced there. So he came to me and asked me, so what do I do? I said, well, your only option is to go file a suit independently in Australia. He said, it will cost me more to go to Australia and file a suit. I will give up the thing. If it is a non-conforming, non-signatory to the treaty, then you can do nothing because they don't recognize your orders. So, also separate that a country like Australia does not recognize our decrees.
Right, sir. Salman sir, would you like to say something on this as well? Or this is it live that we have?
I can't improve upon that. That's in tribute to Justice Shri Krishna, his vast experience.
Absolutely. So with this, we would like to end this session and thank you so much for accepting our invitation, being here and full-fledgedly telling us each and every concepts of enforceability of award to both of you. My personal thank you to both of you.
Okay.
And before I conclude the session, I would request Dr. Rao to give vote of thanks to the participants and panelists and everybody here. Dr. Rao, over to you.
Yes. Am I audible, Dhruti?
Yes, pretty well.
Yeah. Thank you, Advocate Dhuti. I extend my heartfelt thanks to Honorable Mr. Justice B.N. Shri Krishna sir for sharing his valuable time on this beautiful Sunday morning. And we are always excited to hear from you, sir, and always want to hear more from you. Also, we want to thank you for extending your warm relationship with our university, not with just this webinar, but also other courses. And I hope in future also you would extend that. So thank you very much, sir. I also want to thank Senior Advocate Salman Khurshid ji for readily accepting our invitation. We always look forward to listening sir's interesting analysis of laws, policy, judicial pronouncement, and that of feasible, practical feasibilities. So thank you very much, sir. It was again an interesting, enlightening experience to hear from both of you stalwarts in the field of law. I also want to thank Honorable Vice Chancellor of this university, Professor Dr. Dilip Uke, and Registrar Professor Dr. Anil Variat, sir, for guiding us in organizing this national webinar. This webinar could not have been possible without the efforts of Advocate Dhruti Kapadia. So thank you, Dhruti. And most importantly, I want to thank participants who have joined us in numbers through this online platform and also through YouTube. So thank you all. I hope you would be there for our future programs also. I want to thank Mr. Manohar for IT support and Lawlex as our media partner. Thank you very much.
Just one last thing before we close. I would like to give a special thanks to Dr. Anil Vairat, sir, who was coordinating, supportive, and always in for us to do this webinar. Thank you so much, sir.
Thank you very much for brightening up the day with your yellow dress. Thank you very much.
Thank you, sir.
Thank you.
Thank you, Judge. Thank you, Judge. Thank you. Goodbye. Goodbye, everybody.
Thanks a lot.
Good luck.
Thanks
Thanks.
a lot, sir. Thanks a lot.
Bye. We close now. Thank you all.
Thank you.
Thank you very much, everybody.